I'll let you know and we're good to go. All right, Gina, good to go.
All right. Good morning or afternoon. No, is it afternoon? It's afternoon. Yikes.
Yeah.
It's a Monday. Okay. So before we start with Suzanne's report and then our discussion of the latest issue in this issue that keeps giving, I will read the Ethics Act statement. It is the duty of subcommittee members to avoid conflicts of interest and appearances of conflicts of interest in performing the duties as a member of the, what I'm calling the INRI Brocker Inquiry Re Lawyer Participation in Google Screen Paper Lead Advertising Program subcommittee of the North Carolina State Bar. Any member of the subcommittee who's aware of any personal conflicts or appearances thereof with respect to the matters before this subcommittee should disclose those at the meeting, either up front or on an as-we-go basis before you bump into one. I think we ought to be okay, though. And so without further ado, Suzanne, I will punt to you to take it away and tell us where we are and where we're going.
Well, I think everybody's pretty up to date with what we're doing. This is the inquiry that deals with the Google Legal Services ad, and the issue, what makes this different than the other types of advertisements we've looked at before is that the contact information is not the lawyer's contact information. It actually is a Google number. So any call from a consumer goes through a Google platform. And when it does that, the communication is recorded and it's retained for a certain amount of time and possibly given to third parties or accessible by third parties. And so the issue is whether lawyers may participate in this type of advertising program. And we had a subcommittee meeting where we decided that a consumer contacting a lawyer through a legal service ad was a prospective client, and therefore they were entitled to all the protections that are set out in Rule 1.18. And going through that analysis, there's a duty of confidentiality. And so we were discussing the fact that the lawyer could not get consent to have the potential client's information turned over to third parties. And so that was basically how we said that lawyers were not allowed to participate because they couldn't comply with the duty of confidentiality owed to a prospective client. So when I sat down and tried to write it, I looked at what we define as prospective client in the comments, and I looked at what information is provided on the legal service ad, and it looks like that they might not be a prospective client. And Warren talked about this at the last meeting, and I should have paid more attention to him, but I don't generally, so I might have to start from now on.
I start now.
I forgot what I was going to say. So I know that we don't want to say that anybody that responds to an ad that only contains the amount of information that is on the legal service ad. That's why I sent you the screenshots this morning. We don't want to say anybody that responds to an ad that only has a lawyer's name, number, area of practice is a prospective client. So that's where we are. We need to determine if we're for sure going to say they're not a prospective client. I don't know how we can say they are. And if they're not a prospective client, then where does that leave us as far as permissibility for lawyers to participate?
Well,
Mr. Savage.
thank you, Madam Chair. No, I was, so instead of relying upon the confidentiality concerns that we have and conflict concerns that we have when somebody calls as a prospective client, because we don't want those duties to kick in if somebody just picks up the phone and calls a lawyer based on what they find on the internet. Instead, do we go back to you can't put out misleading information in a advertisement? Is that where we go to? Then you're not worried is it misleading to put a false number, or not a false number, a number that's not yours, that will record the call, and then and have a link that's not yours? Is that misleading? I don't know, but that's the only way I can think to get around. Lawyers can't advertise in a misleading way, whether it's to prospective clients or just the general public, right? So that's the only way I can think to get around trying to enumerate or to distinguish this from just calling somebody on in response to their website information.
I think that's exactly right. And I see it as, unfortunately, two completely distinct issues. I think that his point is, if they're advertising a telephone number, I think most people assume that the telephone number belongs to you because you're representing that it belongs to you, and that there's some sort of understanding that people aren't eavesdropping or recording it or using it for other purposes that are unrelated to the reason that you're calling for a professional service. So I think the ad in and of itself is problematic for the reasons that he just stated. And then when we go forward and if we still need to analyze it further after making that distinction, I looked at this language, Suzanne, that you had included in comment 2 to the rule that you had bolded about when such a person becomes a prospective client. And it says such a person is communicating information unilaterally to a lawyer without any reasonable expectation that the lawyer is willing to discuss the possibility of forming a client-lawyer relationship. And I feel like Google's a little bit like a dating service. I mean, they are advertising that this lawyer wants to be your lawyer. And so it is all about the reasonable expectation of a relationship forming. So this is not like a tombstone ad in a newspaper. This is an invitation to call me and let me be your lawyer. I'm just not telling you that our consultation is being recorded by a third party and could be used for the third party services. Now, we talked before about that information being in the whisper ad, but in any event, so I saw it as two completely distinct issues.
Since I'm already having been outed as missing the previous meeting on this by Justice Lever, I wanted to make sure, assuming things tends to get me in trouble. Are we aware, or has it been discussed, whether or not the whisper message at the beginning complies with the law of all 50 states about two-party notice and two-party disclosure on recording phone calls? Is that something y'all talked about last time?
No.
No, and I mean, we wouldn't really talk about it. That's a legal issue. So we wouldn't really talk about that in the ethics opinion. I mean, if we knew.
Yeah.
Go ahead.
Well, except that we don't want to invite lawyers to do this and get themselves in trouble. Although I guess in North Carolina, you don't have to tell the other.
Right, but I mean, as far as the misleading nature of the advertisement, that the extent to which it might jam somebody up in the context of recorded phone calls. Again, I haven't researched it. I didn't know if y'all talked about that before, but that just when I was reading through the stuff this morning, I got curious about that.
Yeah, what if somebody calls you from New York City where they have something that says you have to have both parties consent to taping it, and it's being taped? I don't know. That's an interesting question. To me, is it misleading because the whisper ad is window dressing and is really not effective at all to get across the idea that, look, you don't say a damn word unless you understand this and click I understand or something like that. Like you might do when you call or send an email to somebody's email address that you find on their website. And then I don't know, it just, or that there's not something just flashing up there on Google, on the Google screen ad page, drop page or whatever it is that says, call here, click here for call. That is not confidential. Is that, something like that, or here's the number for a non-confidential call. It doesn't say that, and it's this whisper thing that, I don't know.
Well, and we certainly don't want to get in the business, I would not think, of encouraging non-confidential communications between attorneys and clients or attorneys and prospective clients.
But they're not prospective.
Potential clients. Maybe not supposed to.
Well, it's a very important distinction.
It is, actually.
You've got duty of confidentiality to a prospective client. So it's very important to make sure that we don't overstep here.
Well, if I can ask a question that, and I know this is kind of in response to Gina's kind of distinction that she drew. And you guys may have talked about this. I apologize. I haven't made the prior meetings either, but the notion of a prospective client, is there a difference? Like Gina had said, this is different than some sort of, phone book advertisement, right? That when you are participating in Google Screen, you, the lawyer, are proactively requesting not just participation, but knowing that participation includes a phone number that is direct to the lawyer. That's different than the lawyer's, I guess, paid for, or maybe just kind of traditional phone line. And you're paying for it in both situations. But the point is that as opposed to my advertisement where I'm displaying something, I've actually partnered with Google to create a direct line of communication to my office. And is that the distinction from that language in comment 2, where they were talking about prospective clients, or somebody's not a prospective client when somebody is communicating unilaterally to a lawyer without any reasonable expectation the lawyer is willing to discuss the possibility of forming this client-lawyer relationship, is proactively being a part of Google Screen, proactively requesting a specific number from Google through which the client can contact that. Is that a communication of sorts that is initiated by the lawyer, such that the lawyer has you've eliminated this concern without any reasonable expectation that a lawyer is willing to discuss the possibility of forming this relationship? I think the lawyer is very much willing to, and a client should have the reasonable expectation that a lawyer is willing to discuss the possibility of forming this client-lawyer relationship, because the lawyer has taken the steps to essentially purchase a direct line to them via Google. I'm not, and I guess I want to be clear, I'm not trying to advocate a particular answer. I'm trying to think out loud about this, because it is such a fine line. And the thing, Warren, when you said 7.1, I was actually looking at 7.1 and thinking, is this an omission of fact that is necessary to make the overall advertisement accurate? And so maybe this is a 7.1 issue, not necessarily a prospective client thing, but does that get eliminated if there is a statement, like you said, whether it's the whisper statement or whether Google starts putting out there, because Google does change their advertising. We saw that with their keyword advertising about a decade ago, when it went from, what was it called, sponsored links to advertisements. So I guess the point is that if Google put something on there saying, this call may be recorded for quality assurance or something like that, would that eliminate the 7.1 concern, because now there's a more factually accurate thing even though lawyer hasn't really been able to have the chance to advise this potential client, we'll call them, that anything you say is not going to be confidential, and really do not say anything that you intend to be privileged. You know, it really needs to be limited to the bare bones. What's your name? When do you want to come in to discuss this further? You know, you don't want to intentionally prejudice this potential client, or at least this individual who's trying to get something. So I don't know. I know I'm articulating two different things there. The 7.1 seems to me to be a potential solution, but I wonder if basically that can get wiped away with an amendment to their business practice, whereas the prospective client may just need to be something that is that more of a distinction.
I mean, I think if we do it that way, we have to be prepared to say, yes, that Google can fix that. Right? I mean, we have to be, if they don't make it misleading, then yeah, you can be part of this.
Well, but then that kicks us into the other analysis, because the recording is absolutely not for quality assurance. It is for Google to use for their own good or to give somebody else, because we don't need, as between lawyer and client, we don't need a third party to assure our quality. That's what the state bar is for. So, you know, that's not the issue here. And so I think that takes us from the ad analysis, which I think Warren has articulated the issue, into the secondary analysis about the parameters of the relationship once you move into actual client land.
Right.
By having the call. So could we do that, Suzanne? Could we break it down into multiple inquiries? I know you love when that happens.
No, sure. I mean, yes, we probably will have to.
Well, can we discuss it in terms of not acknowledging that these are not prospective clients, but stating that the understanding of anybody that calls a law office seeking to hire a law firm is that that conversation is not going to have a third party listening to it, and that unless there is something more affirmative that the client has to do to acknowledge that they've been advised of this and that they understand it and they accept it, excuse me, not the client, the caller, that you can't do that just because the experience of potential clients is that they call a law firm and want to talk only to that law firm. They may get told no, that even under our present rules, that conversation is not confidential, but and might be compelled by a court if you know to produce the contents of that call or that communication. But the lawyer shouldn't engage in something that creates a third party that everybody knows is on there, unless there's something more assertive that the client has actually had to click a box and say, I understand this, and I still want the call to go through, or something like that.
Yeah, that was oh, sorry, go ahead, Gina.
I think we talked about that, and I think we all prefer the idea of an affirmative action by the caller where they are acknowledging informed consent about this, a little bit like the HIPAA privacy statement that you sign at the doctor's office, something that the client reads, checks the box affirmatively, and signs before the call can be recorded. That certainly is something that I think we decided we would feel better about, and that the whisper ad didn't really trigger any informed consent at all. And I think we looked at that a couple meetings ago, and I think we had a consensus that that was true.
Could we put a I don't know if it's a requirement, but should the opinion articulate that a lawyer has a responsibility to, I guess, at the outset of the call, remind the client? You know, a client has come to lawyer, and should lawyer then say, maybe when they pick up, and I know that unless they have a specific setup with a different phone that rings as a result of these Google numbers, which I don't imagine they would, but maybe that has to become a practice. Did you call using Google Screen? Yes or no? Yes. Okay, do you understand that this call is being recorded right now and we need to have a separate call? We should not discuss anything substantive about your case, but we should, talk about, maybe even just if it's the bare bones of, I want to talk to you about a criminal representation. And what time can you come in, and we'll set up a separate call to talk to each other. Is that a responsibility of the lawyer to protect that client's interests? Maybe we're not even into prospective client land, but I think we're still in this thing where, if there is a change in Google's, Google's advertising or the language that's around this particular call, that the lawyer should still have an interest in protecting this individual's rights as and this is the whole thing where it's like, well, what's the duty? You're not calling them a prospective client. Is this a prejudicial to the administration of justice thing, that essentially talking with someone who's intending or expecting confidentiality and or protected privilege, that it would be prejudicial to the administration of justice for a client or an individual seeking legal services to reach out to a lawyer with those expectations and discover that those expectations were null. They did not apply. And that should be on lawyer, because lawyer is using this service to ensure a client is aware.
I think we did talk about a little bit, Brian. I think the way it works is when the call is forwarded, the lawyer answers. When the lawyer picks up the phone, it says, this is a call from Google. So
Okay.
But the other thing that I think Ripley talked about and Gina was, even if you start talking, even if you say, don't say anything, there's going to be clients that say, I know, but blah, 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 before you have a chance to cut them off. So,
I understand that can happen, but is that something that we can say the lawyer should address that first, but recognizing that might not always happen, and still allow them to do this? Does that make sense? Say if you're going to use this service, you at least have this duty to try to do that. But if when you know that it's somebody that's called through this Google service, my concern is, however, the effectiveness of the lawyer still. The client doesn't understand the difference between finding somebody on Google or finding somebody on Google Screened, or finding somebody, or just, I use the internet. They may not even know what the hell they're using. And if the person that's calling is asked by the lawyer, did you find me through Google Screened advertising service? They're going to go,
Yeah, right. Yeah.
well, they know that.
That's not me, but
That's Suzanne's security detail that was finding on prospective client versus potential client.
I hesitate though I don't know. I always hesitate to put more duties on lawyers.
Yeah, I know. And I know. And that's, I guess I want to be clear. I'm trying to think out loud on this one too. I'm not totally convinced of it, because it really is such a tough and very fine line that we're dealing with here. I'm curious, Lamar, I've seen you nodding here and there. What are you thinking?
Yeah, I've got competing thoughts swimming in my mind, as it sounds like everybody else does. Yeah, I was looking at, I looked at 8.4 before you said something about prejudicial to the administration of justice. And I also think, although maybe a bit awkward, the shoe might fit for 8.4C, talking about engaging in dishonest conduct where you're knowingly signing someone up to a take phone call with Google and not explaining it to them.
Right.
So that could be another end around. you talk about informed consent, you look at 1.0F and the definition of informed consent. And I think this speaks to Warren's point about what's reasonable in the circumstances. And it talks about, an agreement for a proposed course of conduct after the lawyer has communicated adequate information and explanation appropriate to the circumstances. So maybe that can be an end around of do the best you can, as Warren's saying, even though there are, sometimes that someone's going to continue to blabber. I mean, heck, we as lawyers deal with that from time to time, where we tell clients, consistent with our obligation, keep this between you and me. Don't go talking to your neighbor or your buddy or whatever about what we're talking about. And once you've told them that, you can't put a muzzle on them, right? Like if they go and do it and they breach or they break confidentiality or attorney-client, then they've done it. But you've met you can't control what someone does after you've met your objective or your duty. So I don't know. I mean, I too hate to put additional burdens on lawyers, but as it's currently constituted, I don't know that we have any choice, because we can't just say don't participate at all in this program, I don't think. But then once you do, I think you have to say, you as a lawyer have a duty to protect confidentiality, no different than if anybody else were participating in this call who's neither a top attorney nor a prospective client. And if you don't want to go to the 1.18 prospective client, I think that Brian, maybe a little awkward fit, but I think you're right. 8.4 could be in and around there. I don't think, lastly, and then I'll shut up, I don't think that just dealing with the advertising piece of it gets us where we need to go. Because even if we talk about it being a misleading ad, which I think has its own issues, that doesn't address what I think we as a group thought was the biggest problem with this whole scenario the last time we talked, which is the fact that Google records it, and more than just for quality assurance, or regardless of the reason they record it. And I think that was what bothered people more than anything else, and what the potential implications of that are. Just my thoughts. I'm not giving you any concrete, here's what I think we ought to do, but I mostly agree with the fact that we're walking a fine line, but I think it's a fine line that we've got to walk, unfortunately.
Well, and to use your analogy a little bit here, it's not like the lawyer has a confidential communication with the client, warns the client not to share it, and the client does share it. This is the lawyer's the one going and spreading the confidential communication. The lawyer's the one who's invited Google to listen in, not the client.
That's true. Although I will say, to some degree, if you think about this in a much broader context, we all kind of operate with a see no evil, hear no evil. I mean, Gmail monitors our emails and will then send us advertisings because we put in our email that I wrote to Gina that I'd meet her at, such and such restaurant to discuss my case. And then there's a advertisement showing up in my social media thing for that same restaurant. So, you know what I mean? I mean, that kind of is happening already.
Don't make me answer that question, Warren, on whether lawyers should be using Gmail.
I know, I'm not, but I am saying, we've been asked this, but there are all kinds of means of communication that we have, we'll have a hard time distinguishing this from others. As far as we know, all Google's doing is having some algorithm listen to this, and the same way that Google has an algorithm monitoring your Gmail for whatever reason.
Right. Well, and I think that's the thing that, where this one is so unique, because what you're describing, we're talking about established attorney-client relationships where you have a duty under 1.6 to keep that stuff protected.
Right.
And these folks are responding to an ad that basically, if it was an ad not through Google screened, you can search on Google and you'll see the number and you can click call, and it's not necessarily through Google screen. It just directs you to their phone number. It's a convenient thing on your smartphone. that would be somebody responding to an ad that we wouldn't consider a prospective client until there's that manifest intention between client and
Right.
lawyer that they want to form this relationship, or at least they're going to explore the relationship, forming the relationship, as opposed to just, hey, calling you out of the blue. And that's where I was trying to think of it. Gina, your point that Google is the lawyer has invited Google to listen in on it. I was trying to take this out of the electronic context and think of it like an actual in-person situation of, somebody walks out of court, they find out they just got, maybe they just got indicted or something like that. And they're walking out, they're like, gosh, I got to get a lawyer for this one. And somebody's sitting off to the side and, they say, information about legal services. And they've got a list of 4 or 5 local lawyers that you could go check out. And the person goes over and says, yeah, let me go take a look at lawyer A here. This sounds like somebody I'll just go talk to. And the person gets up from behind the desk and says, okay, I'll go with you, and shows up at lawyer's office. And now client has this other random person that shows up at lawyer's office and basically is like, let's talk. We just want to kind of explore, I need representation in a criminal matter. And I would think that as a lawyer, your first response would be, who's this? And you want them to sit in on our conversation right now. I feel like I got to tell you, if you don't know who this person is, they're just along for the ride. There's some implications with this. I feel like that would be our natural reaction to somebody listening in on a conversation with a client who may not actually reach the prospective client level, but just that initial. If you're not telling me this is mom or dad or spouse or whatever, this is just some random person. That's all right. We need to make sure that you're aware of it. But okay, that's these are the implications. But here's where we go. And I guess that's the weird thing with Google. You've essentially, lawyer has, like you said, Gina, is kind of a different scenario where like lawyer has invited this third party in that's assisting with the connection. It's a referral service in that regard, but the referral service is actually sitting in the room as you have this very first conversation. It's such a weird thing. I think that's why we're all very hesitant. It feels wrong. It feels icky, to use a technical term, but it is, I don't know. I kind of feel like maybe the thing that makes the most sense from what we're talking about today is starting off with the ad itself, omitting something that's crucial for the clients or the potential clients understanding. But then once the communication has been initiated, that it is on lawyer to ensure that client is aware of the implications of this conversation, namely the conversation occurring through Google, because to not do so would be prejudicial to the administration of justice. As far as what the client's expectation is. And if the client just ignores or just talks over you, then maybe that's something that's out of your control. I'm going to shut up now.
Oh.
Gina?
Have to respond?
Yeah, sorry, I was muted again. Well, I looked back at that Wisconsin, when it Wisconsin, Suzanne, I looked back at that again too. And I mean, I think that sounds like where we're kind of coming down is analyzing the advertising in and of itself without contact between lawyer and caller. And that's one inquiry. And then the second one is, at what point does the person become a potential client, using the language out of Wisconsin, and what duties arise between potential client and prospective client? Is there a difference? Are those two different things?
Yeah.
Yeah. And so talk about duties to potential client and then duties to prospective client that are heightened.
can we call it something other than potential client? Just random public caller?
I like that
I mean-
term, random public caller.
I mean, I just don't, using the word client in that
Right.
description to me in any way, shape, or form almost creates a category that is otherwise undefined, and I don't want to mess with it. Just
Any
I
member of the
absolutely-
public, right?
What'd you say, Lamar?
Just said any member of the public.
yeah, who calls that number.
So Suzanne, does this help or hurt?
I'm not sure.
I think we're doing exactly the same. This will be the third time that we're getting into the weeds and adding things to the analysis. And remind me, I think what we decided to do was to try to be as general as possible, right?
Well, you're definitely going to make it generic, try to take out the whole Google name, but that should be fairly easy. I can do that. I'm just less clear about what else I'm doing.
Okay,
I think that the ad is misleading, and because of the omission, but then I also think that if we said that, then they would just change and put some type of disclaimer in there, so that would make the whole opinion irrelevant.
Are there other types of communications, whether it be through somebody calls it, looks you up on Avo, some referral service, anywhere else where the implications of what we say here might, have an effect on those that are already existing right now? I'm just trying to think. I mean,
There is, I think I mentioned this in our last meeting. I assume there's still the ability to do this. I know in the past, you can create a unique number and use that to track calls, and other people do it. It's not just Google. We had a company that designed and maintained our website one time where they had a unique number that when people saw it on our website and called through that number, we knew that's where we got it from. Now, we, of course, made sure that the data and it was confidential and nobody's recording anything, nobody's saving anything. So,
right.
But there is the ability out there, and I wish I had more tech savvy so I could explain to you how and what iterations it is. But there is the ability out there to have a unique number that you use for tracking purposes, and that's not just limited to Google.
But it's not recorded.
Yeah, I mean, right.
Like I said, ignorance is bliss. I mean,
Maybe it is, yeah.
it's not recorded because
No, it should be recorded. Or again, under the same analysis, if it is, you better darn well make sure that you've got consent for that. So just understand that if we do something in the advertising piece, whatever, if we say that having a unique number through this ad and not telling people in advance that this isn't your own office number.
I don't think that's going to be the only part of it, though. I think it's
okay.
that it's going through another platform, and that platform is recording and retaining the communication.
Right, but I'm just saying, just from the advertising piece standpoint, are we saying that the providing that unique number without explaining that it's Google's number is misleading? If we do that, then just have to understand that we might be affecting other areas as well. Anyway.
But I think we would not say that it was misleading only because of that. We would say it's the material omission is that it's being recorded.
Right. Okay.
Well, I think that's this is the part where it's like the substantial or potential for substantial harm really comes out in a different way than some of those lawyer referral services that you see online, where maybe you plug in, I'm looking for a business attorney in this zip code, and here's my contact information, and the referral service can send stuff and, you know, all that stuff, but it's very limited to the bare bones stuff that maybe we don't have as much concern as far as, you know, like the client has obviously given this information to a third party that they realize is not a lawyer, but is connecting them with a lawyer. But when we're talking about an actual live phone call, that's where you, like, you know, to your point, Gina, that stuff can just kind of go all over the place. That conversation can go anywhere. As much as lawyers trying to say, just tell me your name and let's schedule a time to get you in here so we can have a conversation. It can go so many different directions. And that I think, I don't know if that's something to articulate in the opinion as far as the reason for kind of going past the advertisement and what it says, but the reason that a lawyer has this additional duty to ensure that the client, or I guess this person from the public who has called your office, is aware of the impact that using this service will have on their rights. It makes sure that is clear to the client, and to try to, I guess, limit the conversation to be as non-substantive as possible, and save the substance for later.
It's almost like you as a lawyer have created a duty, a duty to act, to warn by what you've already done, which is signing them up for something that they're unaware of.
Right. It's,
I mean, getting back to something I said earlier, I mean, couldn't we fashion it as that members of the general public expect that when they call a lawyer's office, that the lawyer is not inviting a third person to listen to that call, period. Then say that the platform as it now stands does not effectively communicate or get the client, get the callers, fully inform the caller and get their affirmative consent to make the call, knowing that it's being recorded, and then leave it at that. I mean, because beyond that, you know, if the client wants to make that call and they say they understand that it's being recorded, I mean, what can we do beyond that? I mean, and the lawyer, tell the lawyer they ought to, you know, make sure they understand that the client still understands that, and do a little spiel before actually getting anything from the client. But other than that, I mean,
but I think there's even another layer. And I think if my recollection serves me correctly, this is a couple of meetings ago, and it was Ripley and I who raised this issue, because of course I'm coming at it from a domestic case standpoint, and he was coming at it from a criminal case standpoint. And we don't even know that informed consent, that we even want to make that available, because what we're doing is we're saying to everybody, if I'm a Google screened lawyer and my opposing attorneys know that, then they immediately file a lawsuit and send a subpoena to Google for that recorded initial client consultation. So I don't really want to, even if the client understands that the communication is not confidential, does the client understand that we're creating evidence that can and will be used against the client by the opposing party down the road?
well, if somebody responds to calls you now, Gina, unsolicited, based on your information, and just starts blurting shit at you, and you go, I'm not touching you with a 10-foot pole, I think you could be subpoenaed to testify about that right now.
I agree, and it's why I don't do that anymore. I don't ever take those calls. And so nobody can blurt anything to me. Now, I guess somebody could run into me at the grocery store and say, hey, aren't you a divorce lawyer? Blah, and I'd have to run away. But I think it is dangerous, absolutely, to put a lawyer in a position where they could get information and it not be in the protected bubble. And obviously, it's a bigger concern for defendants in criminal cases, because the chances of the opposing party in a domestic case finding a lawyer and getting a subpoena out fast enough. But in the criminal case, where the government could be watching the guy's phone logs for all of I know, I mean, they're going to get those subpoenas out fast enough to get that information.
And if the world of jail calls has given us any information, I mean, every 90 to 120 seconds, there's a burst of this call is being recorded by a law enforcement agency, and it doesn't slow anyone down at all. And it maybe even encourages them. I mean, as many jail calls as I've listened to where everybody's just talking and talking and talking and talking and talking. That kind of information doesn't slow anybody down.
And then again, we go back to our mission, which is to protect the public. And we're not doing that here. Even if we could protect the lawyer, maybe, but we can't protect the members of the public.
Well, let's just say it's not allowed then, and say, don't do it in terms of proposed prospective client, but just say it's impossible. In real time, it would be next to impossible for the attorney to get informed consent. And I was just looking up our terminology for informed consent, and we talk about and it defines informed consent as an agreement by a person, not by a client, or even a prospective client. It's by a person after that person's gotten adequate information and an explanation from the attorney appropriate to the circumstances. So, and I think it seems to me that the consensus here is that you're never going to be able to get informed consent, right? In the context of somebody just calling you and you picking up the phone and being able to say, don't say a word until I give you this 5-minute explanation, give you an opportunity to think about it, give you an opportunity to agree or not agree, and may explain the potential consequences if you continue with this conversation, which is the only way you can have informed consent, right? And then leave it to Google to try to fix that. I mean,
Suzanne, we can see your wheels turning.
No, I'm just listening.
I mean, don't we all agree that we don't like that the situation of inviting somebody to call you on it'd be one thing if you were making the recording. At least then you're making the recording, you have control over it. This is a third party you have no control over. I don't know.
The way the disclaimer is worded in the stuff that's circulated in the passive voice, it doesn't make it clear in my mind that Google is the one recording it and not the lawyer, which to me is a different animal.
In the whisper message, you mean?
Right. It just, it uses some sort of passive voice about this call may be recorded. It doesn't say that the call is being recorded by Google, which is unrelated to the lawyer and, an outside party to any communication between the lawyer and the person, not even the prospective client.
I agree with that, Rip.
I mean, I feel like I can write that there's no way for them to get informed consent, but how do I get to the fact that they have to get informed consent? Where's the duty coming from?
The duty of the lawyer to protect the public from putting themselves in precarious situation when calling the attorney.
What rule number is that one?
The Warren .1, subsection B. But I mean, lawyers have a duty to the public to not, I mean, it's misleading under 7.1 unless you can get adequate information to the person when they call you to understand the consequence, right? Isn't that what we're saying? Would there be a duty drawn out of your duty not to be misleading, participate in misleading, and that it's misleading because people, when they call an attorney, expect that call not to have a third person listening,
Well,
monitoring it, and recording it for unknown purposes.
Rule 1.0 in terminology defining 1.0F, defining informed consent, talks about the agreement between a person and a lawyer, not a client and a lawyer. So, I mean, you can say within the context of communication under, as you know, defined with respect to informed consent under 1.0 subsection F, that it's the informed consent to the communication is not possible based on the nature of the disclosure by Google, something like that.
Rule 7.1A1, it's misleading if you omit a fact necessary to make the statement considered as a whole not materially misleading. So is that something where you can't include all the facts that you need to get informed? I don't know. It's freaking keep circling back on myself. I don't know.
I know. Well, that's where I feel like the 7.1 does plan for the omission of the fact that can be remedied with an appropriate change by Google, appropriate disclaimer. And we're still in that spot where even if there's an appropriate disclaimer, it sounds like we all still don't really like the thought that this call is being recorded. So we don't want to call them prospective clients because of the ramifications. I mean, I have to go back to that slightly and just say I do think this could potentially be distinguished from the ordinary prospective client because lawyer has proactively participated in this program. You know, in a way, I'm looking at that language that Suzanne sent out. We're focusing on the part that's bolded, but the language that's before that, this is comment 2 to rule 1.18, that's talking about, prospective client is somebody who's consulting with the lawyer about forming this relationship, and that it can occur in a variety of different ways depending upon the circumstances. They give a little example there, but essentially the example is saying that if the lawyer, either in person or through the lawyer's advertising in any medium, specifically requests or invites the submission of information about a potential representation without these clear and reasonably understandable warnings that limit the lawyer's obligations, that this person, that's essentially saying that is a consultation, and therefore the person is a prospective client, is lawyer, by signing up for Google Screen, essentially requesting or inviting the submission of information through this medium about a potential representation without those reasonably understandable warnings and cautionary statements that would limit the lawyer's responsibility. And therefore, the use of Google Screened does create a prospective client relationship. Not in ordinary circumstances, but just in the use of this. And of course, it goes on that next sentence, to avoid the creation of a duty to the person under this rule, a lawyer has an affirmative obligation to warn the person that communication with the lawyer will not create a client-lawyer relationship. Information conveyed will not be confidential and privileged. And again, it goes back to that whole notion that, yeah, it's on, hopefully Google will improve the communication, their transparency of what's going on here, but it's really on the lawyer. If they are seeking out Google Screen services, if they're signing up for it, are they then essentially engaging in consultations just by inviting the submission of this information from members of the public, from persons who are seeking legal services, that otherwise, if they weren't using Google Screen, those folks would not be prospective clients. But because you're using Google Screen, they're prospective clients, and therefore all the responsibilities fall under there, and including the duty of confidentiality, which you are then breaching because this is being recorded.
It makes me think of going to some of the more sophisticated plaintiffs' lawyers' websites, where as soon as you get on their website, a little window pops up and says, hey, you want to talk to a lawyer? Hey, you want to talk to a lawyer? Click here, click here, click here. I think it would be pretty hard to say that if somebody clicked on that, they weren't a prospective client,
Yeah.
Right? As opposed to you just have a link to your email in a regular bio on your firm website. That's different, don't you think? Than this little floating window that follows you from page to page. Click here if you want to talk to a lawyer.
Right.
I don't know.
So
Can we send it back to Deanna?
she's
She's
been
on the
mighty
call here.
quiet over
throughout
there.
all of this.
I've seen her little microphone has been on red with, she's back. She's with us.
I have nothing to add. I'm just a fly on the wall.
Uh-huh.
So Suzanne, as usual, Brian has persuaded me. I feel like I'm easy. Remind me why, which I hate, but remind me why we disavowed that analysis last time with the prospective client.
To me, it was the language in the comment that said, a prospective client is not somebody that responds to an ad that only sets out the lawyer's name, address, contact information. It was that sentence, because that's exactly what is in the lawyer's Google ad. The first screenshot I sent you, that's what you see. The lawyer's name, phone number, I don't know what else. And if you click on that,
Email.
that doesn't seem different from what that sentence in the comment says. But I think what Brian said might work. Yeah, because see that if you click on the call there, you're responding to an ad that only sets out a person's name and what you think is their phone number.
But it doesn't say, but it does, I guess, as Brian is saying, that the distinction is that clicking that call doesn't say call, click here to call and make a recorded, have a third party record your conversation.
No, but that goes back to the prospective client versus the misleading ad. I mean, it's
Right. Yeah.
My issue was with that sentence in the comment that basically described what.
Right.
And Warren, I mean, you pointed that out at the last meeting.
But
what Brian is saying might work, where you say, regardless of the ads appearing the same, the fact that you have signed up for this service kicks you out of that just having your name and your phone number there.
Well, I mean, there's more than just the name and the phone number. There's the, 287 reviews, the fact that they're Google screened, the fact that it's sponsored. Does that take it out?
Well, that if you click on their page, then you go to that second screenshot. But the first screenshot, Brian, can you put that back up there, Vanna? Just if you call from there, it doesn't say anything.
Wait, which one did you want? The first one or the second one?
The one that has the least amount of information. It does say Google screened. Yes, Ripley, that is true.
And it says sponsored, and it has, that her rating is 4.4 and there are 287 reviews.
So if this wasn't good, if it wasn't being recorded, then Ripley, would you say that somebody that called that was a prospective client? I mean, I don't think you would.
I wouldn't.
Because I think that's what a lot of the ads that are already out there
Oh, yeah.
include. I mean, if you click on one of these two lawyers' faces or whatever, it goes to that second page, which does have more information. But if you were just to call from this first page, it's hard for me to make that different from which comment is it that has that language?
2.
Comment 2.
Yeah, 2.
In contrast, a consultation does not occur if a person provides information in response to an advertising that merely describes the lawyer's education experience, areas of practice, and contact information.
That seems, the Google screen and all that seems to be outside of that to me.
Okay.
Because that doesn't have anything to do with their years of practice or their education or any of that.
My issue with that, I don't disagree, is that I think that maybe there's other ads like Avo or something else that would be similar. And I don't know. We just have to be careful about what we say as a prospective client.
Agreed.
I mean, I agree. I'm not trying to say that I mean, I would like to say they are a prospective client. That would be my preference. I'm just struggling with how to get there.
Yeah, but I mean, that creates the scenario where I can conflict Gina out by just calling her up on her Google screen thing and saying, nanny, I just talked to you. Of course, that would be bad faith. That doesn't actually get you.
Right.
Well, and the comment specifically addresses that and says that doesn't count.
I know, you're right. But I could
Yeah.
call you and then decide, I don't, wait a minute, I'm going to call this other person. Could get you conflicted out just by calling that number.
Well, I guess that would be the thing, that if we are saying that this person is a prospective client, like if we go down that pathway, you use Google Screen, you get clients through Google Screen, or somebody calls you through Google Screen, therefore they are a prospective client, therefore you owe a duty of confidentiality to them. And in that regard, you cannot participate in Google Screen because you are immediately breaching that duty of confidentiality without getting any warning or this notion of informed consent from the person. And I don't know if, like, are we saying that I guess maybe, is that the pathway to no, you should not participate that? If that is what, I'm not trying to, kind of figure out our pathway to a conclusion, we need to let the rules draw our conclusion. But can you actually preserve confidentiality and maintain your duties to the client when you know that your communication is automatically recorded by a third party?
No, that's the easy part. The hard part is getting to the duty in my mind. If there's a duty, you're not going to meet it. But where does the duty come from?
Right.
And the first part of what you just said, Brian, was, I can't remember, but basically I'm afraid it would apply to other
Yeah, yeah. No,
Yeah.
when you said that if this was not a recorded call, would we feel that any of these folks that have an advertisement on Google right now and you click call,
Right.
does that make them prospective clients? And no, it that doesn't seem right. And I think not to mention it would be very commercially restrictive on lawyers and their advertising in today's mediums. This one just kind of adds this additional thing of recording it, which just feels wrong, and feels like the client could be taken advantage of. And I think, Gina, your example is a really good one, that you find out, your opposing counsel find out that this person was called through Google Screen. What's stopping them from subpoenaing these records? That initial call recorded.
Which is why it's potentially prejudicial to the administration of justice.
Right. I agree with you, Mark. I feel like that's if we don't feel comfortable, the kind of the ripple effect of prospective client, which I think it is a pretty significant ripple effect, that as much as I see a pathway there, if the ripple effect throws that off, then prejudicial 8.4D is really what we're left with, because of the harm that it creates for this person seeking legal services. And our duty in protecting the public, I think, not just warrants it, but really kind of compels a conclusion that lawyers, now I guess must at the very least warn, and maybe taking that language from comment 2 to rule 1.18 that says, that essentially you have a duty to make this person not a prospective client. You need to provide the appropriate warnings. A lawyer has an affirmative obligation to warn the person that a communication with the lawyer will not create a client-lawyer relationship, and information conveyed will not be confidential or privileged. It's that ongoing duty. But ultimately, in addition, you have kind of the larger idea that a member of the public seeking legal services has an expectation, and a reasonable one at that the information they're providing, that their conversation is not to say that it's confidential, but that it is not being recorded by a third party.
Well, it's like, sort of like, if somebody calls you up and says they want to discuss hiring you, you don't tell them, okay, meet me at the gym and we'll discuss the possibility around 20 other people who are all sitting there in the same room about whether you'll be where I can talk to you about your case, and you can ask me whether, we can talk about whether you want to be I don't invite somebody who is looking for a lawyer to come talk to me in a non-confidential setting, I guess is my point. They may
Same deal with these three-way jail calls where it's somebody's cousin or neighbor or whatever and the lawyer. That ain't a confidential communication.
Right. And you're not creating that situation. The state creates that, right? And the only way you can talk to your client might be, or their client could get in touch with you is through that. But this is one where you are creating that situation. You are creating a non-confidential setting to meet with public who want to discuss potentially hiring you.
Okay. You want me to give that a shot?
Warren,
Good luck.
Warren,
Yes.
1.1 subsection C.
Right.
All right.
Okay. As usual, we're past our hour. Anybody got anything else to add to Suzanne's plate?
Colin, did you want to say anything?
Thank you, but no, I've enjoyed this interesting discussion. It's a difficult issue, and we're probably going to get more of these as technology continues to change.
Yeah.
Exactly.
Into that.
Okay.
Yeah, give me a lot to think about and try to work with. So
there's also going to be a lot of lawyers who are already doing this Google screen program who are going to have a lot of input on this.
I'm not sure how many in North Carolina are doing it already.
Well,
I think there's a fair amount based on what I've heard. I know I've had some folks that have called and said, well, we're looking at it right now. I'm sure Deanna's probably heard a lot of folks that are participating in this, or at least they're testing out, trying to determine if they can or so.
There's 2 Asheville family lawyers
Okay.
right now, I see.
Oh yeah, I just Googled family law Raleigh, North Carolina, and I see there's at least 3 that pop up as far as Google screen, but just scrolling through, it looks like there's maybe 10 listed here. So it's
Really?
Yeah, that's what I did when I was trying to figure it out. I went through one of the divorce lawyers and I went all the way through where the phone connects or something, and I heard the little whisper message, and then I said, I have the wrong number. It's hard to understand how it works unless you actually do it. So
Right.
I did it. But yeah.
Okay, so I think this is really a U-turn. I think we're back where we started a couple times ago, which seems to be a pattern. But I guess it means we're really thinking through it hard.
Well, I'm not sure we're going to say that they're prospective clients. That's one. I'm going to look at what Brian said.
Understood.
But then also we might say that it's just a general duty, 8.4.
No, I meant with the duty.
Okay.
Whatever kind of duty it is to whoever, whatever kind of people it's a duty to. Okay, well, if you will work on that and then just circulate something back for us to look at. And do we think there's a reasonable chance we can have another of these before July?
I hope so.
Okay.
That would be my hope.
Okay.
I know everybody's probably super busy now that we can leave our houses, but I hope we can.
Okay, perfect.
But not next week because I'm going to Mexico.
Atta girl, have fun.
Nice.
As soon as we got vaccinated, my husband was making reservations. So
I was going to say something inappropriate, but we're being live.
Thank you, Warren. Thank you for self-censoring. Gina, shall I stop the live stream?
Yes.